Remember this kid, Success Kid, the kid who was eating sand and we turned him into a model for memes about feeling good about successes? Well, the parents own the copyright in the photograph and they've happily allowed it to be used for many different memes and even sold it for money. They were involved in a lawsuit against racist Congressman Steve King, and having won that, Steve King is now seeking Supreme Court review on two novel issues. So as a background, they sued him for copyright infringement because Steve King used the Success Kid meme as part of his campaign when he was seeking re-election as a racist congressman from the District of Columbia. And he lost at trial. The owners of the copyright won, and they only obtained a verdict of $750 from the jury. So there are two big issues in the petition for a Supreme Court review. One is the implied license. King argues that by letting everybody use the meme and encouraging the world to use the meme, there is an essential implied license for everybody on the internet to take that picture and make their own Success Kid meme, including King, who used it in his campaign. The judge rejected that theory of the implied license, finding that an implied license applies when there is a transaction from one to another. So there can be implied license when you know the person you are giving the implied license to, but it's not something you give the entire world. The second is a procedural issue that's very important for copyright lawyers. So pay attention. This is going to be very important for people enforcing their rights. King is seeking attorney's fees, even though he lost at trial. And to get there, I have to explain a few rules. Number one, the general so-called American rule, which is if you win a lawsuit, you are ordinarily not entitled to your attorney's fees against the other party unless it's authorized by statute or contract. Now, the Copyright Act does have attorney's fees by statute. It's Section 505, and it says the prevailing party can get attorney's fees, and it's discretionary with the judge whether or not they get it. Of course, Steve King was not the prevailing party. The plaintiffs won, even though the judgment was small. Enter Rule 68. King had, before they went to trial, made an offer of judgment under Federal Rule 68 for $15,000. They went to trial, plaintiffs won, but they did not obtain a judgment as good as the $15,000 offer. So Rule 68 kicks in, and from that moment where he made the offer, King is entitled to costs under the rule. And costs are associated with certain filing fees and other expenses associated with trial, but costs typically do not include attorney's fees. King is arguing in the context of copyright only, those costs would include his attorney's fees, because if you look at the plain wording of 505, it appears to include attorney's fees under the definition of costs. So this petition is before the United States Supreme Court now. Understand that the Supreme Court only takes a very small minority of cases that is presented to them, so it's quite likely that this is the last we hear of it. My name is Mark Jaffe, Five Bridges Law, representing creatives in California and New York.